for someone that is not not yet, maybe the criminal in the case, the perpetrator, the tortfeasor, the wrongdoer, the shooter, right? That can be pretty difficult too. And I thought you guys kept a lot of that discussion out. In Florida now, the law just changed that in negligent security cases, or I would assume in a case like this, I've never tried a case exactly like this, that the shooter's name would be on the verdict form and we would have to argue the difference in percentage of fault, including the shooter. What's the law like in Virginia when it comes to that?
Yeah, I practice a lot in Arizona, and
Okay.
that's how it is in Arizona. You get essentially a third party at fault on the verdict form. But in Virginia, Virginia still has joint and several liability, and and there it's a contrib state. Although contrib doesn't apply in this context, it sort of educates or informs a lot of the law here, which is that there is no third party on the verdict form ever. And the only way that somebody gets on the verdict form is if they're pled in some way to be a party in the case, either a third party defendant, plaintiff, or an actual defendant in the case. And so there is pretty good law in Virginia about eliminating, and we probably talked about this at some length during the trial, about eliminating the empty chair, or making sure that there is no discussion or there's no pointing of the fingers to somebody who's not actually a party to the litigation. And so that's good
Which they
law.
were kind of trying to do with the other teachers. Like, oh, Mr. Rawls or this person, they knew all this and didn't do it as well, which you guys differentiated in like, they knew this, she knew all of this kind of thing.
Yeah, and I don't think you'd have to tell me, did Court TV pick up the voir dire? I don't think they did jury
No,
selection.
I did not watch it. I don't know if they
Yeah.
picked it up, but I did not watch it.
So that was a big part of questions that we asked in jury selection. And there was a jury questionnaire that asked them about their impressions and et cetera. And there were some folks who reflected that they had concerns, or that they felt like a situation like this starts at home, for example. Like, are the parents are going to be
So
involved?
many people in my chat, so many people said the same exact thing. Like,
Yeah.
where's this kid's mom? How did this happen with this? Starts there. Then, kid, how are we at the school level? How are we dealing with an assistant principal? So many people ask that, which I always think the chat amazingly is such a good representation of like general jurors out there. And again, they'd get struck in a lot of cases like this, but that's really interesting. So you guys dealt with a lot of this, which makes sense, right? If they're going to put it all on mom or they're going to put it all on 6-year-old, then they might not be right for this jury.
Yeah, and so the way that we tried to address it in voir dire is I said, look, when we get involved in these cases and we get into a courtroom, sometimes there are folks that you think might share some responsibility in what happened. But ultimately, you're being asked only to decide what responsibility, if any, there is of the person here. You're not going to be asked to compare. You're not going to be asked to contrast. You're not going to be asked to weigh the differences. You're only going to be asked to say, did they do something wrong that you found was culpable? And then was that a proximate cause? And then I sort of explained to jurors, what does that mean preliminarily? You can have multiple people be a proximate cause. It doesn't have to be a single person. And so we knew that that was a strategy that they were going to pursue, whether it be the boy, whether it be the other teachers or whoever, parents, for example. And so we tried to front load that thought process and get affirmation from jurors. Hey, I know you said this on your verdict form, but if you decide this case, and I say to jurors, I say, look, I'm concerned. Do you understand why I'm concerned? I'm concerned that you'll get into this case and you won't be able to put aside the parents, and they're not going to be here. You're not going to hear it from them. I'm worried that that's going to be knocking on the door in the jury room, trying to make its way into your decision when we know that it can't. Is that a fair concern? And some people will say it's a fair concern. I don't know that I can get rid of it. And some people will say, I hear you. I can separate that. And I say, okay, if you're telling me that you can separate that, I accept that. And there are jurors that sat on the case that said exactly that, that said, I think it starts at home, but I can separate that. And they sat on the jury and ultimately rendered their verdict.
Yeah, it's so interesting dealing with all of that. I'm sure another thing you had to deal with at some point in jury selection was gun control. That was another thing a lot of people want to talk about is the laws. We need to change the gun. I'm like, I understand that, and people have their views on that, but that's not going to affect. We're already here. So now we're
Yeah.
dealing with this and the fault that lies in this trial. How did you deal with that in jury selection?
Yeah, it was on the questionnaire, but I will say that the judge in pretrial motions also indicated that that really wasn't going to be what we're trying this case about, and sort of headed off some of that
Okay.
in motions in limine practice. And from our perspective, consistent with what you said, it really wasn't about that by the time the gun's on campus, right? Like, if by the time the gun's on campus, it is what it is, and you got to deal with the threat as it's
Right.
posed at that time. And so there were questions on the questionnaire asking people generally what their views were of gun violence or experiences with gun violence or gun control, and it was helpful to get a sense of what people's understanding or appreciation of the issues were, but it wasn't really determinative for us because we knew it wouldn't come up in earnest during the trial.
Yeah, and I meant to ask this when we were talking before about, whether it's mom or son, um, and you don't have any third parties on the verdict form, which is great. But there's a little bit of a trade-off here that's much, much worse in Virginia than in Florida, and I think Arizona too doesn't have the 1% rule. Like if she's 1% at fault at Barzal recovery, which is the craziest like law of all time to me, because I've had cases that where they're almost admitting fault and the jury will still put 10% on the other party for whatever reason, right? Huge number, but 10% because it's some kind of compromise back there so that we can get a unanimous verdict. But you guys made it clear, or actually the defense made it more clear than you did, I thought, which is helpful because it's like if you want us to win, you can't put even 1% on her. If you think she's 1%, she loses. So is that really what you want? Which almost just sounds like a verdict for the defense. But how do you deal with that 1% rule?
Yeah, it's the way that it's just the way that life is in Virginia, so I think that, look, I think ultimately you have to frame it in the context of it's not doing a thing that is contributing 1%. It's doing a wrong thing that is contributing a 1%. And in cases, I didn't focus it that much on this closing argument, but there were parts where I think in my closing I said, look, their job was to sound the alarm. They were the watchmen and they did their job. Now you've got to do your job. And that was sort of uh, an ode to this idea that they satisfied what requirements there were of them, including Miss Zwerner, of doing what she was supposed to do. She was non-negligent. But a lot of times what you see in Virginia is that a defense lawyer will come up and they'll take a piece of paper and they'll rip off the corner and they say, even if she's this percent at fault, then she cannot recover any of the piece of paper. And, we've dealt with that in different ways. And I think if, to your point, if the jurors internalize, okay, what is the true result of the decision of making a contributory negligence finding, I think it allows them to see things in more clarity and say, okay, let's really make sure we're applying this appropriately and not just saying, oh yes, she did a thing that was 1% at fault, but let's say, was it a negligent thing? Was it a wrong thing? And there's an instruction that I think I talked about in rebuttal that I often like in cases like this, which is that that a plaintiff has the right to assume a defendant is going to act in due care, and therefore when somebody is sort of expecting that somebody else is going to do their job appropriately, it's not negligent for them to be waiting for somebody else to do their job. That is allowed. That's allowed in the law.
Yeah. And I really think that human beings generally, this is not like a cut to jurors to say they like things simple, but human beings generally like to simplify things. They don't want to overcomplicate things, especially if they're in an uncomfortable position or making a big decision they've never made before. And I've always thought that whole 1% rule, our state has tried to push it because we used to, it's going in that direction for us too. But I've always thought it's just their lobbyists use it so that insurance companies and defendants can use it in negotiation more than anything. I've only got to prove 1% and you lose. because I think once you explain the principle to the jury, 1% means they lose. So 1% is 100%. It's kind of simple. It's kind of an either or. You're still picking a winner. And I think if you simplify that to the jury, it can really work in your favor more than sometimes, just a normal contribute where they're putting a certain percentage on your client. So I think from my perspective that you guys handled it well and the jury understood that it was all or nothing. Basically, it wasn't five. Okay, let's say 5% she was at fault. They weren't going to do that analysis back there, in my opinion, which I think is helpful for you.